The Supreme Court with a landmark ruling on abortion in Texas. This one could reverberate nationwide. We'll look at that and other high-profile cases the High Court handed down. Then, more fallout from the British vote to exit the EU. We'll debate how it's impacting us stateside. Then a brand new poll is out, and it shows Hillary Clinton opening up a double-digit lead on the Donald. But some of the other things in the same poll could be even more damaging to Mr. Trump. Evening, everybody, and welcome to RFL. I'm Richard French. Thanks so much for joining us. Hope you had a good weekend. We start the week here with the Supreme Court and a big ruling on abortion.
Women want today! Women want today!
As expected, Justice Kennedy held the key vote, deciding that the state of Texas went too far in its regulations, striking them down 5-3 and setting a precedent for the country. The justices heard arguments in early March, the first after the death of Justice Antonin Scalia, who's expected to have backed Texas in this case. On the steps of the court, passion from both sides.
The Supreme Court put the so-called right to abortion above the right to safety.
The Texas law requires that abortion clinics are more like surgical centers and that doctors have admitting privileges at a hospital within 30 miles. Critics say those regulations make it impossible for many centers to stay open. Since the law was enacted, half of the clinics in Texas closed. Hence, the law's opponents argued an undue burden.
After years of fighting heartless, anti-choice politicians who would seemingly stop at nothing to put abortion out of reach, I want everybody to understand, you don't mess with Texas women.
Lawyers representing the state of Texas and anti-abortion activists, they argued the regulations were put in place to protect women's health.
Babies lost and their mothers lost.
All right, let's bring in our panel to get into this on all things SCOTUS. We talked to Mark Furnish, professor of Brooklyn Law. He's argued, well, with everyone, but also before the U.S. Supreme Court. Dominic Carter, political journalist and author. Brad Gersman, political consultant, founding partner of Gotham Government Relations, attorney in his own right from Radier, and also talk about a special project he's working on. Andrew Whitman, our senior political correspondent. Okay, Mark, another case I want to get to too, but let's first start off with this one. In effect, the court found that without getting into pro-life, pro-choice, they were putting an undue burden on these clinics where they were, in all intents and purposes, trying to force them to have what was equivalent of like a major hospital in terms of ERs and everything else that was cost prohibitive.
Right. They found, first of all, that it wasn't really medically necessary because the prior regime, the advocates of this law didn't point to any problems with it. And they found, exactly as you said in the lead-up, that it posed a substantial obstacle to abortion and there was an undue burden on the right. And basically that the law was a pretext to restrict women's access to the right of abortion.
How about implications beyond just this case?
Well, I think the implications are this. For Republicans, I think, everyone on the left has this great project in mind on the part of the Supreme Court, Republicans, to repeal Roe versus Wade, and we've been talking about this for decades already. Not going to happen. The court really doesn't have that much of an appetite. It's an incrementalist court under Roberts. It doesn't have that much of an appetite to take these great, big, huge steps. So it's not really a fruitful line of avenue for the Republicans to pursue to suggest that abortion is in grave danger.
And also a 5-3 ruling with ostensibly that seat, assuming we'll get into the politics later on in the program, it could be another. No. It seems to somebody on the outside, you obviously watch the court much closer than me, is it wrong to say the Roberts court, and I don't mean this pejoratively necessarily, seems like a political court, not just at what it's born out of, but there's unpredictable rulings, which sometimes I think is good because it means you can't prejudge the case here necessarily where it's going to go, but that sometimes there's trade-offs. We'll give you this, we'll get that.
Well, there's no question that the Supreme Court is a political court, as Judge Posner, the prominent judge on the Seventh Circuit, has written many times in books on the subject. But today's rulings, and this one in particular, seems actually like a less politicized ruling that we've been getting from them in recent cases. Kennedy was the swing vote. As you said, Scalia's absence was not deeply felt in this case, wouldn't have made a difference. I think this was pretty straightforward. It was a very burdensome law without much medical justification.
I want to get to another ruling. This might have been dealing with Virginia, but it has implications for New York, and I'll explain. The court threw out the conviction of former Virginia Governor Bob McDonnell. He's the Republican that was convicted of corruption for receiving money and loans in return for political favors. Supreme Court ruling it could be a game changer in political corruption cases as it narrowed what could be considered corruption. I'll talk about the New York in a second, but Brad, also, to me, if you're taking gifts and in effect you're providing either access or favors as a result, this thing looked like game, set, match when they laid out what him and the wife were doing here. How's this not corruption?
Well, they speak, the Supreme Court spoke to an official act. And the question is are setting up meetings or, having meetings or these kind of things official acts, and they're not official acts. And truly, I think this was an accurate decision. I think this makes sense. Yeah, because it still has to be a crime. Let's
No, but
there was a lot of
clearly
ugliness,
enriched
and even
himself to me.
No, but even the court said there's ugliness to this. They don't, they're not condoning the behavior. However, there still has to be a crime. You still have to, do something proactively.
I mean, that's what we've seen here, abusing the public trust.
That's too vague. It's very vague.
That's not the issue.
Yeah.
The issue is quid pro quo. Governor McDonnell, by all accounts, accepted $165,000 from this donor. But what the donor wanted was for his dietary supplement to receive a state research grant. He never got the grant. So based on that definition, there's no quid pro quo. And Sheldon Silver, Dean Skelos,
I was going to get there in a second.
Overturned.
But just one thing.
No, wait. Now hold the
Wait,
phone.
hold on. Wait, before we get there. Where Dominic says 165 grand, the governor and his wife are living high off the hog, off of the treatment here that nobody thinks is legitimate behavior, where somebody who has business before the state is, in my eyes, enriching. You say a different term here, the governor's wife.
Here's the thing. Well, first of all, they're not off the hook because the case very well could be retried. The case was reversed on a narrow jury instruction error, but what's instructive is what you said in the lead up to the piece. You said access is part of corruption, and the ruling means no, it's not. Just paying for access is the stuff of ordinary politics, because a politician, after all, is supposed to be accessible to his or her constituents and to facilitate meetings with other
But it seems like that makes the standard, Mark. You need an email that says, I am giving you $160,000 and you are doing X, Y, and Z for me.
In the political corruption context, as we've political contribution context, as we've talked about on the show many times, you do need an express agreement because political contributions are protected by the First Amendment. So you don't want to chill that. But what you have to do, according to this case today, is agree, not actually do it, agree to take an official decision or to commit an official action on behalf of the donor, not to just grant the donor preferential access.
So,
you have to put a finger on the decision-making
If he had attempted to help this
if he
donor,
had
that would also be?
If there were proof, and there very well could be produced proof at a retrial, if he attempted to influence the decision-making of another official, to put a thumb on the scale, that very well could be actionable.
A meeting, and I couldn't agree more with, and it was a tremendous way of describing it. But the fact is, setting up a meeting is just involving yourself in the regular day-to-day business of politics.
Dom, you said obviously the implications for New York. The former Assembly Speaker Shelley Silver and the Senate Majority Leader Dean Skelos.
Dominic got carried away.
Okay.
He blurted that
Here's
out.
what I think he
How
may
much
be
is he
right.
paying you?
Could he, isn't there an argument? I still think what Shelley Silver did, and how he directly enriched himself, that is, in many ways, to me, a quid pro quo. However,
Rich, there's the quid is what you get, and the quo is what you do. Okay, this decision dealt with the quo today, not with the enriching. So what Silver did in allocating state funds to the doctor is unquestionably an official action.
No, that's not completely accurate, because his lawyers put up full graphs that he did this for hospitals around the state.
Right, but that's a factual defense. That doesn't mean that he didn't take an official action.
Okay,
he did.
Counselor, you're the expert, so maybe you'll prove to be right in this case. But let me just say this, Richard, as it relates to Silver and Skelos, Judge Kimber Wood, Judge Valerie Caproni, notice neither one is in jail right
Now,
now
wait a minute.
because
Well, that
they
is
were
true.
they were waiting.
Yes.
They were waiting for the.
Skelos
Yeah, but they
has a
were-
much stronger claim
Okay,
because
right,
what
he does.
Skelos
He
did
does,
on the
but-
official action ground, getting somebody a job, getting the son a job in the private sector, not official
No, but
action.
awarding the contract.
that
But
is official action.
But
getting
here's
the-
what
that
happened
is
every
correct.
day. Here's the conclusion I reached. It's very scary to sit in a federal courtroom. If you're a defendant,
You think?
walking in, you're almost done before the case starts. That's number one, no matter who you are, no matter what lawyer you have. It was very scary to watch. Prosecutors have this vague ability to say corruption.
But that's what this case
And,
is about.
right, and it's not right, and it's not fair.
Yeah, but that's
You
Wait
can't-
a minute.
Richard,
No,
Richard,
he's
Richard,
not
Richard,
Rich. He's
Richard,
not.
you
Supreme
can't
Court
just
just
say-
narrowed.
Richard, you can't just go. I'm sorry, this is America. You can't just go corruption.
Okay, wait.
And
Okay,
and
hold
they
on.
can.
Tom, one second.
When you read
they
the
didn't
text-
just go corruption.
Yes, they did.
What
Yes, they
Shelley
did.
Silver
No,
did.
yes,
Let's
they
start with
did.
Shelley Silver. He systematically used taxpayer money to direct money, time out,
It's
to
not
get
that
cases
clear.
to enrich. It's
He's a
crystal
lawyer.
clear.
Lawyers refer clients every single day, and they get referral
Here's the-
fees
here's
when
the-
they do absolutely no work on
With
the
taxpayer
case.
money.
No,
It's
no, no,
very
With
vague.
taxpayer money.
Wait.
Here's the thing
It's
about
more a
here's-
function of the fact that he gave the money to that institution. Okay, that was his official act. He didn't need
And
to.
there were email
he didn't
threads
need
saying
to
he was
have
expecting
a, right,
business
and he
coming
didn't
back.
need to have a meeting for that because he could do it himself.
Wait,
He's the speaker.
That is
So
true.
he was able to do that official act himself, give the money, and in return he got cases. And that's the quid pro quo. And
Yeah.
Well,
there's-
wait a second. That's the thing. Where Silver has play in the joints is not on official action because he's down on that. There was very, very unequivocal testimony at the trial by the doctor that there was no quid pro quo. He did not understand Silver to have agreed upon this for that.
Even
That's
though,
a
by the
different
way,
argument.
His email threads seem to indicate otherwise.
And
Okay.
the other thing
Well,
that
that's what the
Silver
jury
has
decided
is
on.
to have an extortion under color of right, there has to be an obtaining of property. And what I've said a lot of times on this program is that these patient leads, which are really just medical charts, I don't think they constitute property within the meaning of the law.
So now let's get to Skelos for a second.
The obtainable property, let's say that.
Skelos clearly tried to put pressure on certain people to get Junior a job. Okay.
That's not official action, and those counts are going to be in some serious trouble to the degree that's alleged to be the official action. The government contracts threatening or promising to take action on matters within his legislative jurisdiction, that's squarely official action, and that's
Andrew,
going
you
nowhere.
step back from this. The ruling today, as it relates to McDonald going forward, there's a general assumption. Forget the barristers at the table here, that we expect the governor, speaker, a Senate Majority Leader, that when you go there, you're supposed to be doing, quote unquote, the people's business. That if you do anything to use your office to further enrich yourself or to enrich your families as a consequence, that I always had assumed was criminal, and I get the clarifications today. You guys spelled it out really well. But that's certainly not the expectation of the public in terms of what they should be getting.
I think that's fair on a macro level, but I think you could also make the argument that politicians and elected officials enrich themselves and their families all the time. All the time, whether it's through, I mean, ideally not through official actions that they're taking, but, I mean, does anybody argue, and I realize this is a particularly electric one, but that Bill Clinton wasn't getting increased speaker's fees because of the position
But that was
his
when he was
wife
out
had?
of office.
No, but she was in office. His wife was in office. Or you could make the argument that other spouses or kids wind up getting bigger gigs than they might otherwise get because of the position that they're
But
relative
again,
to.
they got it themselves. They didn't have somebody saying from the Secretary of State, if you don't give him speaking fees, by the way, I'm going to make sure we're going to cut off foreign aid. That would be criminal.
Yes, it would be.
So that's my distinction with the difference. We can say it's splitting hairs, but I think it's different.
But this
I
ruling
think
today
this
wasn't,
ruling
this ruling
goes.
today wasn't about good government. It was about the specific charges
I
of
grant
corruption.
you
Exactly
on
what
that.
the opinion says, that the federal prosecutors should not be in the business of setting standards for good government. Now, keep in mind, what McDonald did was not criminal under Virginia law. Federal prosecutors went in, intervened, and brought a criminal case for conduct.
I got to hit a
that was
break here,
not
but I'm only
unlawful
saying
in
this much.
Virginia.
If you broadly apply what the Supreme Court said today as it relates to McDonald, I think we're going to have a harder time here expecting better governance and it's not going to be a good day.
I don't think so. I disagree, respectfully.
You don't do it respectfully at all. Coming up next here, we'll stay in the political world. Triple trouble for Donald Trump. Like how I said that, the poll numbers that are not looking good for the Donald. Then the race to become Hillary's running mate might make Andrew happy here, but a lot of people wondering if she should be, the one on the left there, the best running mate. Stay with us.